Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Hello everyone. Alright. First of all, we would like to thanks to our lecturer, Ustazah Azizun Saleh, for her valuable guidance and moral support throughout the period of completing this assignment. So today, our group would like to present about the role of Syariah courts in matters pertaining to Muslim inheritance. We hope you guys can understand clearly about this topic and enjoy our video presentations. Before we start our presentation, let me introduce our group members. Firstly, I'm Nurfilza binti Muhammad Effendi. Second, Nurul Afika binti Syahyumi. Third, Fakrul Amar bin Abdul Rahman. And lastly, Nur Hazwani binti Abdul Razak.
The objectives of this assignment will be focusing on the role of Sharia court in matters pertaining to Muslim inheritance, the differences between the Sharia and civil court in matters pertaining to Muslim inheritance, and lastly, the issues and problems of Sharia courts in matters pertaining to Muslim inheritance. So, before we go further, I will start with a little bit of introduction about this topic. Bismillahirrahmanirrahim. My name is Nurul Afika binti Syahyumi. My matric number is 2019230062. So inheritance is defined as the process of devolving property upon the death of its owner. According to Morgan, it means the distribution of deceased property among the cognate kindred. It is also believed to be transfer of an article from one person to another, which involves the transfer of wealth, knowledge, honor, or dignity. In Malaysia, the civil court and Sharia court exist by side in dual court structure. The civil court were established as federal courts to deal with federal matters, whereas the Sharia courts are provided for in the federal constitution as state courts that can be established to deal with matters of Islamic law. The understanding of the Sharia court as subordinate to the civil court has arguably been altered following the introduction of an amendment to Article 121, subset 1A of the Constitution following the Constitutional Amendment Act 1988. Article 121, subset 1A now provides that the civil court shall have no jurisdiction in respect of any matters within the jurisdiction of the Sharia court. The general jurisdiction of the Sharia court is expressly provided for in the Federal Constitution under Article 74, subsect 2, and List 2, Schedule 9. Sharia courts have jurisdiction over Islamic law and personal and family law of person professing the religion of Islam. Therefore, the Sharia court plays a significant role in matters pertaining to Muslim inheritance as one of the administrative bodies. Although the extent of jurisdiction and power possessed by the Sharia court may not be as wide as the civil court, the role of Sharia court in this context is nevertheless substantial, as it is literally determines the recipients and the respective portion by way of faraid formula. This fact justifies the reason behind the Sharia court being the first administrative body which the beneficiaries need to approach, not only for the issuance of inheritance certificate, but for the purpose of resolving other related matters which are under the jurisdiction of Sharia court. Upon the settlement of these matters, only then the beneficiaries may proceed in applying for the letters of representation from other administrative bodies, namely the Civil High Court or Amanah Raya Berhad. In certain cases, the estate distribution unit. Since the civil law also governs parts of the inheritance matters, reference therefore involve both Sharia courts and civil courts.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Hazwani binti Abdul Razak. My matric number is 2019253346. Today, I will explain about the role of Sharia court pertaining to Muslim inheritance. On your screens now shows the roles of Sharia courts. The first role is faraid certificates. The second role is confirmations validity of a charge, weddings declarations, and the last one is concerning disputes related to the issues of property, will, hibah, and wakaf. The first role is the faraid certificates. In linguistics, the word faraid has several interpretations, which is determine, ensure, legalize, and mandates are a few examples. Faraid, in the Islamic language, is the split of the property of a Muslim who has died, not just whether he left a will before his death. Thus, according to Islamic law, his wealth will thereafter be given to his descendants. The property allocated to descendant is the surplus of the property remaining after subtracting all finance for funeral managements, their debts, and will permitted by Islamic law. There are three types of heir who are eligible to get an inheritance, which is for those who are descendant from the heir, those who are married, and those who are wala, which is family relationships. Wives are amongst the heir who can inherit via marriage. When a death has occurred, Islamic teachings dictate that the deceased property be resolved immediately following the process of burial. Often, heirs are perplexed as to where and how the inheritance should be settled. There are a number of distinct institutions in charge of managing the division of this state, as well as a number of particular laws that must be followed by the number of organizations in responsibility. This Fara'id certificate is only used to define all original heir and the allocation that must be made to each person who is identified as an heir. Thus, the application for a Fara'id certificate should only be delayed when there is an issue identifying the heir. Aside from that, this application should be finished as soon as possible. Moreover, an application to the civil court for a letter of administrative authority should never be made upward of 3 years of that. If it is, a justification must be given to the courts. All states in Malaysia, whether via the Islamic Religious Administration Act enactment or the State Syariah Court enactment or ordinance, have particular laws relating to the authorities to issue Fara'id certificates. According to the Administration of Islamic Law, the Syariah High Court has jurisdiction over inheritance matters, which are hearing and deciding all matters involving Muslims, and the partition and inheritance of testamentary or intestate property, as well as the decisions who is entitled to a share in the estates of dead Muslims or what portions each individual is entitled to. Next rule is confirming the validity of a child. The Syariah Court has the power to determine the equality of a child. This is related to matters arising during the process of divisions of the estates. Therefore, the institution that should be the solver of this problem is the role of Syariah Court to determine the validity of a child of their heir in the event of the disputes of invalidity. However, according to Wan Abdul Halim, the Syariah Court has no jurisdiction to determine a property as an inheritance, order the distributions of the deceased property, or give a power of attorney to administer the estates. It is crystal clear in the Johor Islamic Family Law 2003, which provides that the Syariah Court has a role in determining the equality of a child through the stipulations. If the child is born more than 4 years of Qamariah after the marriage is dissolved, either by reason of the man's death or by reason of divorce, the child is divorced. That the Syariah Court has the role in determining whether or not a child is equal to another child in section 112. In summations, the Syariah Court provides assistance and has a role in issue relating to decisions of legitimacy of a child or heir to the dead via the provisions of the law provided for the family legislations of the states. This law may be found in the family law of the states. Next rule is weddings declarations. Allah Subhanahu wa Ta'ala has decided on the rule and manners of divisions of the estate among the heir in order to provide justice to all levels of the heir and to prevent disagreements among them. This was done in order to ensure that the estate is divided fairly. When a person dies, the deceased inheritance must be divided according to the Islamic law, and this necessitates the resolutions of a number of other issues. It is essential to be aware of how to safeguard the inheritance of the dead against the proliferations of malpractice in its distributions to the heir. Nevertheless, before the division is carried out, all rights relating to the estates are in effect. In accordance with the Islamic Sharia, it is necessary to ascertain first whether or not an akad of marriage is legitimate before carrying out the process of distributions inheritance to the heir of the deceased. The Sharia Court for Muslim marriage is only the body that has authority to the role on this matter. In accordance with the provisions of Marriage Clause 11 of the Johor Islamic Family Law Enactment 2003, which was based of the part of Enactment 17 of 2003, the Islamic Family Law Negeri Johor 2003 was enacted in the states of Johor in 2003, based on a provision that states that marriage is invalid unless all conditions are necessary. According to Islamic law, to make it valid, marriage is not valid due to the fact that this provision states that a marriage is invalid unless all conditions necessary, according to Islamic law, to make it valid. Therefore, as invalid marriage will result in the estate of the dead being able to go to the incorrect persons, which will in turn oppress the heir who are more deserving of it. Last rule is concerning disputes related to the issue of property, will, hibah and wakaf. The state Syariah court has the power to ascertain not just whether a will, hibah or wakaf made by a Muslim in accordance with Islamic law is legitimate, but if the matters arise during the claim of the deceased person's estates. This is the case if either will, hibah or wakaf was made during the claim of the deceased person's estates. Through the issue of a faraid certificate, also known as a certificate of inheritance, the Syariah court has the authority to determine who is entitled to what portions of an inheritance. The legislation of the Syariah court in connection to the aforementioned item should be taken into considerations when determining the order in which the estate should be divided. In these respects, the determination of the beneficiaries and the part that will be given to each of the beneficiaries will be provided as a faraid certificates. Therefore, it is abundantly obvious that the Syariah court's authority is constrained to and restricted to just two issues, namely the determination of whose heirs are entitled to the estate as well as the rate of partitions of property alone in the form of a faraid certificates. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Fakr Amar bin Abdul Rahman with ID number 2019, 219 and 226. Okay, today I want to share my part about difference between Syariah court and civil court pertaining to inheritance. If we study thoroughly, the inheritance legal framework in Malaysia is rather unique in terms of estate law. This is because whether Muslims or non-Muslims are governed under different sets of inheritance law, but the law is parallel to each other. Okay, next I will discuss about the civil high court. In comparison, Amanah Raya, Berhad and the Estate Distribution Division, the civil high court has the widest jurisdiction in estate management. Jadi di Malaysia kita ada beberapa institusi yang peranannya menguruskan pentadbiran harta pusaka di Malaysia, seperti yang saya mention tadi, macam Amanah Raya dan Estate Distribution Division. Jadi biasanya pentadbiran harta pusaka di Malaysia akan melibatkan civil high court juga. Jadi dalam kajian saya ni, saya dapati bidang kuasa civil high court ini saya telah senaraikan 4 peranan. Jadi semua boleh lihat di dalam slide yang saya paparkan. The first jurisdiction ataupun bidang kuasa High Court is issuance of probate and letter of administration. Section 24 subsection F of the Court of Judicature Act 1964 established a specific civil jurisdiction of the High Court by authorizing the court to grant probates of wills and testaments and letters of administration of the estates of deceased persons living property, involving two types of representative, namely executor and administrator. Jadi berdasarkan seksyen di atas, seksyen ini telah nyatakan bahawa peranan utama civil high court adalah issuance probate. Jadi apa itu probate? Probate adalah tindakan untuk kita memperakui dan mengesahkan satu wasiat yang ditinggalkan oleh si mati. Jadi tujuan probate adalah untuk memberi pengiktirafan kepada sesuatu wasiat yang sah di sisi undang-undang. The second role ataupun jurisdiction adalah pursuant to the Small Estate Distribution Act under Section 5 provide for the exclusive jurisdiction of the High Court over the deceased testamentary property, as well as a combination of testamentary and intestate property. Jadi apa maksudnya? Menurut Akta Pusaka Kecil, pembahagian di bawah Seksyen 5 memperuntukkan bidang kuasa eksklusif Mahkamah Tinggi ke atas harta berwasiat si mati, serta gabungan harta berwasiat dan tidak berwasiat. The third role is to hear and decide on appeal cases when any party is not satisfied with the division or the issue by the land administrator. Jadi kat sini maksud kalau kita ada ketidakpuashatian dengan pembahagian harta tu, kita bolehlah buat rayuan di civil high court ini. Yang rule yang terakhir adalah this court will involve cases where the deceased asset is under the category of non-small asset. Jadi je aset yang terlibat dalam high court ada dua. First, movable asset yang bernilai 600,000 dan mesti 600,000 dan ke atas. Kedua adalah immovable asset yang bernilai lebih 2 juta ringgit walaupun jumlahnya kurang daripada 2 juta. Kes harta pusaka berwasiat yang melibatkan si mati yang meninggalkan harta akan terletak di bawah bidang kuasa Mahkamah Tinggi Sivil juga. Jadi itu berkenaan tentang Civil High Court. Okay, next discussion about Syariah Court. The provisions of List 2 of the 9th Schedule of the Federal Constitution state that the administration of Islamic affairs is to be the jurisdiction of the state and the Syariah courts. This list is under provision of Syariah court. So you can see this list in the slide. First is family law, matters relating to family in Islam, Baitul Mal, Zakat and Wakaf. Third, mosque, management of mosque, crime, Syariah court and jurisdiction. The matters relating to fatwa. Lastly, control of development of religious teachings. So what I can conclude is we can conclude that matters relating to estate management is under jurisdiction of Syariah court under family law. Next, ciri Syariah court. Ciri Syariah court dalam pengurusan harta pusaka. In slide cirinya limited to Muslim estate and minor jurisdiction. Okay, apabila kita berbincang tentang Syariah court ini, Syariah court ni hanya limited pada harta pusaka orang Islam sahaja. Dan Syariah court ni hanya berurusan dengan kes-kes yang minor. Jadi jika kita nak bandingkan ataupun compare dengan civil court, bidang kuasa civil court ni lebih luas lah nak bandingkan dengan Syariah court ni. Alright, next, two main rule of Syariah court. First, determine the shares distributed to beneficiaries under Islamic law. And second, issue faraid certificate. Jadi sijil faraid ni akan dikeluarkan atas permintaan ataupun request daripada civil court pertama. Kedua, request daripada ataupun pejabat tada atau mana-mana orang yang mendakwa sebagai waris atau wakil pada harta pusaka tersebut. Jadi civil court ni sebelum diorang keluarkan sijil probate ni, mereka civil court ni akan minta untuk dapatkan dulu sijil faraid sebelum diorang akan keluarkan sijil probate tersebut. Jadi apa kandungan dalam sijil faraid tersebut? Okay, faraid certificate contain a list of beneficiaries who are entitled to the deceased estate, as well as the exact portion entitlement of such asset calculated according to the faraid rule as endorsed by the judge. Jadi apa maksudnya? Jadi dalam kandungan sijil tersebut, sijil faraid tersebut, ianya mempunyai senarai waris yang layak untuk dapatkan harta pusaka tersebut lah. Dia mengikut pada portion yang ditetapkan oleh syariah. Dan perkara ini akan disahkan oleh hakim tersebut di mahkamah syariah. Next, discussion about the application of faraid certificate. The application will be heard before the syariah lower court, and the asset must lower than 100,000 ringgit, while syariah high court, the value of asset must more than 100,000 ringgit. Jadi maksudnya permohonan untuk kes di mahkamah rendah syariah, nilai aset tersebut mestilah kurang daripada 100,000 ringgit, manakala untuk mahkamah tinggi syariah nilai aset itu akan lebih daripada 100,000 ringgit. Akan tetapi prosedur itu akan melibatkan juga kedua-dua mahkamah tinggi dan juga Mahkamah Rendah Syariah, di mana sekiranya kes itu dibicarakan di hadapan Mahkamah Rendah Syariah, sijil pusaka akan dikeluarkan oleh Mahkamah Tinggi Syariah. Okay, lastly, after we discuss about the difference between Syariah and Civil High Court, now I will discuss about the relationship between these two courts. So for the first and second point, as we know, Civil High Court will issue the probate certificate, but before the process of issuance probate at High Court, the applicant is required to first obtain the Fara'id certificate before applying the letters of representation. So we can see the relationship at the process in Syariah and Civil Court. Next, for the third point, is about wasiat. Jadi dalam perbincangan mengenai wasiat, rule ini juga digunakan dalam pembahagian wasiat. Sijil faraid tersebut akan menguatkan pewasiat yang akan menerima harta tersebut lah. Jadi kita akan nampak keperluan pengeluaran sijil faraid ini dalam konteks wasiat. What I can conclude is the process of the inheritance management in Malaysia, we can see the duality of the law in Malaysia.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Nurfilzah binti Muhammad Effendi. My number matric is 2019612676. Alright, I will continue the presentations with the third objective of our assignment, which is issue and problems of Sharia court matters pertaining to Muslim inheritance. In discussion about this, the problem that have arisen in Malaysia in relation to Islamic estate planning are not new. And the fact that they have arisen such as that it is some things that should be dealt with in phases through the appropriate channels and authorities. One of the issues Sharia court matters that arising in Muslim inheritance is issues about constraint in the management and administration of Islamic property within the framework of federalism in Malaysia. This discussion shows that Islam has outlined the rules and principles that need to be followed in managing and administering the estate of Muslim. However, there were complaints among the public stating that they were dissatisfied with the service provided. This is because they usually have to go to more than one place to resolve their estate claims. The existing system has allowed for diversity where there are different agencies in managing the affairs of Muslim heritage in Malaysia. But this also creates inconsistencies in the implementations of the duties and responsibilities of the agency. Why? This is because the Muslim estate management and administration system divide power into four main agencies, which is the Civil High Court, Small Estate Office, Department of the Director General of Land and Mines, Amanah Raya Berhad, and Sharia Court. The existence of various agencies in the management and administration of the estate of Muslim has causes confusion among the heirs regarding their supposed agency go for the purpose of estate claims. Next, the second issues of Sharia court matters that arising in Muslim inheritance is statutory restrictions on Sharia court. The result of this study found that almost all legal provision related to the administration of Muslim property limit the jurisdictions of the Sharia court. These provisions include Article 4E Roman 1, List 1 of 9th Schedule of the Federal Constitutions, Court of Justice Act 1964 in Section 4, Probate and Administration Act 1959 in Section 77A. Other than that, Small Estate Distribution Act 1955 in Section 4.1, 12.7 and 19.1A. And lastly, Ministerial Function Act 1961 in Section 2, bracket 2. Based on the above provisions, the Syariah court does not have the power to administer or issues any order related to the divisions of a state. On the other hand, central agencies such as the small inheritance sections or the civil high court or Amanah Raya Berhad have the power to administer or issue any order related to the division of inheritance among Muslims. The Syariah court only has the power to make decisions, while the civil high court has the power to make orders. To give more power to the Syariah courts, the provision in federal law should be reviewed and amended accordingly. The last point is non-uniformity procedure for determinations of heirs is also included in Syariah court issues and problems related to Muslim inheritance. This inconsistency of the procedure for determining the heirs between the Syariah court and other central agency not only causes confusions among the heirs but also slow down the process of divisions of the estate among them. Hence, the existing procedure need to be reviewed and streamlined at the federal level. Improvements to the national Islamic heritage management and administrations system can be done by reviewing the Islamic heritage administration's procedure. This inconsistency occur because the existing system of administration and divisions of Muslim estates separate the jurisdictions of the agencies concerned. Although statutory provisions have emphasized that the Syariah court has the power to determine question of estate, heirs, and inheritance rates. In practice, this matter is not an obligation on other agency to refer to the Syariah court. Why? This is because the theoretical provisions do not oblige the agency to make references to the Syariah court. Alright, one of the example that we can see in section 12 bracket 7 of Small Estate Distributions Act 1955, for example, provided the land administrator shall determine in what manners is most appropriate the law applicable to the descent of the estate of the deceased and shall decide who according to that law is the beneficiary and the share rate and interest respectively. While in section 19(1)(a) of Small Estate Distribution Act 1955 provides if the question relates to Islamic law or Malay costume or native law or costume of Sabah or Sarawak, refer the matters for decisions to the ruler of the state where the district is located or to any other person or group of person as directed by the king. Section 50 of the Administration of Islamic Law, Federal Territories Act 1993 further provides if in the course of any proceeding relating to the administrations or division of the estate of a deceased Muslim, any courts or authority other than a Sharia High Court or a Sharia Subordinate Court shall have the duty to determine the person entitled to the portion of the estate or the portion to which the person are each entitled. The Sharia Court may, on the application of any person claiming that he be the beneficiary or his representative that and having paid by him the prescribed fee, certify the fact found by him and his opinion as to the person entitled to the share in the estate and as to the portion to which they are each entitled. Following the above provisions, there are situations where the decisions to determine the heirs by the Sharia court is not accepted by the small estate office. Even the small estate office will set aside the decisions and issues a new order. In other cases, the method of evidence and proof in the determinations of heirs by the Sharia court is different from the method implemented by the small estate office. The Sharia court does not require all heirs to be present in the determination of heirs, while the small estate office will call all heirs to be present. This can not only cause confusion among the heirs, but also slow down the process of inheritance divisions among the heirs. To overcome this problem, it is proposed that existing heirs determination procedure be reviewed and coordinate at the central level. The legal provisions empowering the small estate office also need to be scrutinized to prevent such cases from continuing. I think that's all from me. Thank you.
As a conclusion, there is still need to improve the legal framework of the administration of Islamic law of property in Malaysia, especially in the matter of standardization. This effort will not be successful without cooperation and support of all state authorities, including individuals or bodies involved in judiciaries and advocatory practice. Nevertheless, the role of Sharia court is undoubtedly essential in ensuring the deceased estate shall be distributed to the entitled beneficiaries with the specific portions in line with the rules of Faraid. It is also a fact that the current practice requires for improvement which could benefit the society, the administrative bodies, and the government as a whole. It is also important to note that the nature of estate administration, which requires the parties to deal with individuals, groups, and agencies, makes it complicated and may be time-consuming. Through the proposed means also, the Muslim shall be able to manage the deceased estate in more efficient and speedier manner as the proposal make it easier to everyone involved. As state Islamic regulation have grown more pervasive and as state courts have become autonomous from the federal courts, there has been a new focus on improving the mechanism by which Islamic law is developed and applied. Among this is concerted effort to upgrade the various Sharia court system around the country. This is supposed to professionalize the operation of the court. It is also supposed to promote harmonization of Islamic law applied in Malaysia, different sub-national units, a harmonization that will not be forcibly imposed by federal judges but voluntarily embraced by a new, highly professional class of Islamic legislator, muftis, and judges. That's all from us. Thank you.